The next matter to come before us this morning is William F. Martin versus Sandra A. Steiner et al. On this case, we have an appellant and we also have a cross-appellant. Both sides will have 15 minutes to argue. Only the appellant may reserve the 5 minutes for rebuttal. I know you both are experienced counsel, you probably know that, but just to let you know, we haven't changed the rules around here. If the appellant would let me know when he gets started, if he wants to reserve any time for rebuttal, I'm keeping the clock. We have read the briefs. We're ready to proceed when you are. Please, we are audio and visual recording, so please stay behind the podium for the duration of your argument. Ready when you are.
Good morning, Your Honors. My name is Brian Barnard. I am here on behalf of William Martin, the plaintiff below. Please, the court, public counsel. I would like to reserve 4 minutes for rebuttal. As far as today's argument is concerned, I would like to focus mostly on our assignments of error 1 through 3. These were assignments of error that involved the validity of this deed that is at issue in this case. So there's a factual backdrop here that's long. I believe the case has been tried twice by my predecessor counsel. I think it came up on appeal once, was reversed and went back to the trial court on the issue of undue influence. Our assignments of error 1 through 3 begin with the court's journal entry. That's clear that the only issue submitted to this jury at the second trial was that of undue influence. If we read Judge Weiss's entry, it says that it was submitted on undue influence. The burdens were explained, I believe, to the jury, and the jury came back that there wasn't any undue influence, and then I think that the defendant had rebutted any presumption in accordance with the court's prior ruling. Devoid in that journal entry is any discussion about the deed. What the deed was it a deed of purchase? Was it a deed of gift? There is no language in the entry that the court considered that, let alone gave an instruction to the jury regarding that. I think it's important to remember, first of all here, that this was a declaratory judgment action, so the plaintiff was asking the court to declare certain things in the complaint. First of all, what was the nature of this deed? Because once we construe this deed, which we believe is a matter of law, and it's a case we've cited, Long Beach Association versus Jones, that was for the court to determine. We don't have any determination in the court's journal entry. What was this deed? Was it a deed of purchase or a deed of gift, as I believe Ms. Steiner, the defendant...
Did you specifically request that the court declare the nature of the deed, or was the sole issue whether or not the deed was valid based on undue influence by Sandra?
I believe the original complaint asked the court to declare whether the deed was, what the status of that deed was.
And that wasn't one of the counts that was dismissed?
No, I believe there was, this one remained. There was a declaratory judgment. There was an intentional, I think, interference with an inheritance, and then I believe there may have been a fraud claim that had been kind of intermingled in there. I know the intentional interference was dismissed at the end of one of the cases, Your Honor, and I'm not sure which one.
That's fine.
The first or the second.
I don't want to take up your time with questions.
But in this matter, we think it was clear that the deed was one of purchase because it had valuable consideration listed in it. It didn't have any language regarding a gift. We think that as for our first assignment of error, it was up to the court to declare that as a matter of law, which they failed to do. That would move us then to our second argument, where once the court declared the deed one of purchase, then we needed to look at the facts. The court needed to look at the facts surrounding the preparation of that deed and analyze that further. We have the case that was this court's decision in Wygand versus Ward, which we rely on heavily here. My understanding, rereading that case and looking at basically what I would determine to be, my opinion, black letter law. It says a fiduciary breaches his or her duty to act in good faith by making a deed with inadequate consideration. Now, in the first appeal of this case, when this court reversed, it found that Sandra was in a fiduciary position. She had a POA at the time, although she didn't sign the deed as power of attorney. She prepared it, or at least in our opinion, she prepared it and gave it to her father to sign. One of those duties was to act in good faith that she had here, and she prepared the deed. Again, it only benefited herself. This was, I believe, a survivorship deed where she had her father sign the deed, giving her the balance of the property at his death. Now, this was in contrary to the will that he had, which left this farm that's in dispute to his children equally, which would have been my client William and the defendant Sandra.
So typically that would be a gift. Father leaves joint survivorship with daughter.
Except for the language of the deed. The language of the deed controls here. And that's back to this case that I cited beforehand. And so whatever the language is in the deed, this one said for valuable consideration. So we believe that that's a deed of purchase at that point, not a deed of gift, regardless of what Sandra testified. That's a matter of law for the judge to determine. Now, clearly, we believe also based on the court's decision in the Wygant case, where it says if a fiduciary breaches his or her duty to act, in good faith by making a deed with inadequate consideration, that's exactly what we had here. There was no consideration paid. There was none. Our position as our argument, or assignment of error number 2, is that based on this, based on the Wygant case, that the judge should have, as a matter of law, ruled that this deed was invalid. It should have never reached the jury.
Directed verdict.
Yes, Your Honor. Yeah. And that's basically what our first 3 assignments of error boil down to, is these should have been matter of law decisions, and they should have never reached the jury. We had a jury, I believe in the transcript, there was some argument amongst Mr. Kennedy and I believe opposing counsel's predecessor, Bob Preston, about whether these matters could even go to the jury. But these 3 assignments of error should not have reached the jury. They should have been the judge declaring these as a matter of law under the Declaratory Judgment Action. And Judge Teodosio, that was my argument then as to my 3rd assignment of error, that because these deeds were one of purchase and that Sandra paid no consideration while she was in a fiduciary relationship, as a matter of law, this should have been a directed verdict.
Counsel, just so, because of the tortured history here, procedural history, when the case was reversed, could the judge have directed a verdict at that point, or was the trial judge required to follow the instructions of the Court of Appeals with respect to what was supposed to be resolved when the case went back down?
Well, I think when the case went back, and I have the court's previous decision here, the only thing that this court said, in a paraphrase, was this is going back for determination of undue influence, okay, because the court did find there was a fiduciary relationship. So that was the court's instruction on remand. But in that first appeal and in the decision, there were 3 other assignments of error 2, 5, and 7 from the first appeal, where we had argued that the trial court, as a matter of law, erred by not finding that this was a deed of purchase. The trial court erred by holding it was a deed as gift. The trial court erred as a matter of law by holding the 2003 deed valid, where there was a failure of consideration and evidence of fraud and bad faith. Now, the court said, we don't need to reach those because we're going to reverse on the issue of undue influence and send it back to the trial court. That's why, rereading the transcript and trying to put this 4 or 5, 6-year case together, in my mind, it appears that it went back on the issue of undue influence, but all of these other assignments of error, which were not addressed by the Court of Appeals in the first case, remain for the trial court to decide. Either for the trial court to decide or to submit to the jury. And I think it's clear from the journal entry, they certainly weren't submitted to the jury because of the journal entry, and also because of the journal entry, the judge did not decide that. That's the crux of our argument here, that the judge needed to declare what these deeds were, and once he did that by following the cases such as Wygant versus Ward, there would have been a directed verdict. There wouldn't have been any reason for the case to go to the jury because this single deed was invalid as a matter of law.
Did he essentially do that when he dismissed the complaint? There's language that says after the jury comes back that we're dismissing the complaint. In other words, it's a ruling on someone's motion for directed verdict, is it not? I understand it's a declaratory judgment action.
Yes. I'm unable to answer that. I guess I can't tell from the record. My hope would be that the judge would put something in there as to the causes of action that were presented. And certainly here, the main one as far as the plaintiff was concerned is what's going on with this deed. And is it valid or not? And we think that that should have certainly been in the entry had the court considered it. We know that it didn't go to the jury. With my remaining time, I'd like to, if I have some time.
You are at 4 minutes and 10 seconds, so you're just now reaching into the rebuttal time.
Okay, I will wait then. Thank you.
Good morning, Your Honors. My name is Jim Woody. I represent Sandra and Linda Steiner, the appellees and cross appellants. I guess I want to first just talk about the case is an unjust, undue influence case. And it's clear there's 3 causes of action for declaratory judgment, for intentional interference with expectancy of inheritance and just the punitive damages kind of standalone. The second one, the intentional interference was dismissed by plaintiff a while ago, I think before the first appeal in this matter. And like counsel, I wasn't involved until late in this because my predecessor left for a judge. So I'm going through the transcript here too. The judge did exactly what this court directed him to do after the first appeal. Up on the first appeal was the issue of, well, what happens when a fiduciary gets transferred some property? Well, she's a fiduciary due to a POA. And then how does that presumption interrelate with the plaintiff's duty to prove by clear and convincing evidence that a deed's invalid due to undue influence? So the fiduciary issue was all wrapped into the prior appeal. So the fact that she was a fiduciary, that was part of the prior appeal, that's part of the law of the case. And that's why it was sent back from this court and given clear directives to follow this burden-shifting analysis where the specific presumption goes first relative to was my client's duty to prove by preponderance of evidence that there wasn't undue influence. And then it shifts. And then there's a high standard there of clear and convincing evidence to prove the deed was procured by undue influence. The jury came back in our favor, in my client's favor. And it's not a de novo review on that issue. It's manifest way of the evidence. Is there any competent, credible evidence in support of it? And we would respectfully submit that the jury's verdict was very well supported, that there was no undue influence here. Without undue influence, there's really nothing left. This happened in 2003 during the lifetime of Chester Martin, the alleged bad acts around there. Sure.
Did Mr. Martin ever have his claim that these deeds were invalid resolved at trial or by the court?
Well, I guess, thank you for the question. As I was listening there, I pulled up the complaint, Your Honor. And I think the answer is yes, but perhaps not in the sense they're stating today. Regarding their first cause of action, in their wherefore at the end, of the plaintiff's wherefore, it says, with respect to the first cause of action, they sought a quote-unquote, a declared judgment that the deeds, exhibits 4 and 5, are void or invalid, and that defendants Sandra Steiner and Linda Steiner have no interest in it. That's exactly what happened here. Went to the jury. The way those deeds would be invalid would be via their only remaining standalone cause
Well,
of action.
the jury found that there was no undue influence, or there was not sufficient undue influence. But what if the deeds were invalid for the reasons that you just heard your opponent argue?
Okay. Well,
They didn't decide that, did they?
Well, it was a general verdict. So I don't know if they decided or not, but they found the deeds were valid, and they had to prove by clear and convincing evidence that they weren't.
Now I see your argument there.
Okay, well, I think I want to go back to that, though, Your Honor.
Sure.
I don't think, it doesn't sound like they're really taking issue with the fact that there would have been evidence supporting the jury verdict of not establishing undue influence. I mean, there's significant evidence there in the record. They had the prior relationship with my client. In 1998, Chester Martin named my client the POA, and the alternate POA was her husband, not his son. He had a record of treating his kids differently in the estate planning process. He effectively close to disinherited one of his other sons in his, I think it was 98 will, and by 08, when the other son passed, he disinherited his kids, his son's kids. And I think this is a really good fact. He changed his will in around 2008. Supposedly, Chester realized that, according to Lisa Attorney Forrest's testimony, that there were problems in 03 regarding the deed, and maybe he didn't like what had happened there. He didn't take Sandra off being executor or Lyndon being alternate executor. I mean, if Chester truly thought he had been treated poorly or unfairly, it would seem strange to entrust your estate to the very people they accused of that. Regarding this, Your Honor, regarding the issue about what they talked about, the fiduciary duty and if the deed is not as a matter of law effectively, I don't think that's the law. The Wygian case, I reread it again last night, and I hope I don't misstate something. Let me pull up my notes. Yes, that I believe that deed was invalidated, but in that situation, the fiduciary did transfer the property. And the fiduciary, I believe, was a trustee, it wasn't a POA. But that's the person that signed the deed, transferred it. I think, let me read here. It was a will that provided that the beneficiary could sell or dispose of real property as the beneficiary deemed advisable. And they did. But the problem was, paraphrasing a little here, is it looked like he sold it for way under market value. And I think the money, the amount of the sale should have gone to the siblings, so they were upset that, why he's selling it for such a little price. But I think the key issue there, at least relative to us, and the distinction is Sandra didn't use her POA, because that's where the fiduciary duty is coming from here. She didn't use the POA to transfer the property. That's not one of these situations. This is the situation that happened that this court addressed on the first appeal. A presumed gift, or at least what's called a transfer, if we don't get into the nature of the deed, was given to somebody who's in a fiduciary capacity, leading to at least leading to the presumption of undue influence that we had my client on the obligation to rebut. It's not a situation where a POA uses the POA, signs a deed to herself, and goes in and takes it. That's making the deed. That is a situation that I think closer to the situation in Wygian, because the Wygian trustee, I believe, signed and did the transfers himself. Here, there's no dispute. Chester Martin signed the document. That's not disputed. So circling, I hope that answers your question, Your Honor. I wasn't trying to miss it. Circling back around to this distinction between a deed of purchase versus a deed of gift, it seems to me it still circles back around to the issue of whether it was a deed or gift. Chester Martin was a father. He's allowed to give his daughter a gift, and he's allowed to sell something to his daughter for whatever price he deems. The question is, was it proper? Was he unduly influenced? Because there's no dispute you can give a gift. even to a fiduciary, because then it raises that presumption, and we go through the process this court laid out. There's no dispute, I don't think, that you can sell something to a fiduciary. And I guess I would say if it was before, if it was lower than market value, my guess would be that perhaps it could be deemed partially a gift, and then you still go through that burden shifting analysis that this court laid out, and I think the Pfeiffer court also had talked about. So I think both roads lead back to the same place. In fact, I was looking at the McCoy case, which is cited in appellant's brief. It's McCoy versus AFTI. And it talks about, it's kind of a relatively similar situation where the deed had the valuable consideration language, but no consideration was given. And it says it's well settled that the mere failure of consideration, whether partial or not, when unmingled with fraud or bad faith, is not sufficient to warrant the rescission of an executed contract, such as a deed. And then it says this.
Unless there's bad faith, right?
Okay.
Go ahead.
Yeah, sure, I'm sorry. Yes. Is generally held in Ohio that parole evidence, which would be evidence that there wasn't consideration paid. In Ohio, that parole evidence is inadmissible to alter, vary, or contradict the consideration expressed in the deed when the purpose or effect of such alteration, variation, or contradiction would change the effect or legal operation of the deed. So we have a legally operative deed here. Whether it's, and it says by consideration, you can't go and get parole evidence to say, well, actually no consideration was given, therefore the deed's cooked. I think you can get parole evidence for other reasons, but that's not one of them. It's not to contradict the deed. But I do think this distinction, again, because it sounds like the focus today from appellant is, I think, assignments of area 1 through 3 and on this fiduciary issue. I think the main thing I see in their briefs, I don't believe the law is that the mere fact that a fiduciary was transferred a property without consideration invalidates. And I don't believe, I think the closest case they cited to was Wygate, and I do not believe that case stands for that proposition. I think your prior case is the one that addresses that situation where the fiduciary is not the one signing the deed and transferring it out. Once we get to bad faith, I'd say undue influence, the jury addressed those issues and came back in favor of Sandra. I would note, I'm going to circle back around to this, is it seems like the assignments of error 1 through 3 and further ones are a lot focused on the jury instructions, what should have been given. From the transcript provided to me, I did not see in there that the actual jury instructions, nor did I see the specific objections on each of these points as required and set forth in our brief. Without that, the court has to assume regularity of proceedings. And beyond that, the bare fact that those requested instructions were not given, presuming they weren't, that's not enough to overturn a jury verdict. They have to be prejudicial pursuant to the statutes and rules we talk about here. I don't believe that's been established in here either. Further note, circling back around, even if all these things are true, taking a variety of the things we're talking about here, there's still a statute of limitations events, whether raised as part of a cross appeal that went up on MSJ and then was renewed afterwards, or just at trial. The same testimony effectively came out. And the key fact was that, at least according to Attorney Ford, Chester Martin came into his office in around 2005 and had some complaints or questions about the deed at issue, and what to do. Ultimately, even according to Attorney Ford, Chester Martin decided to just let it lie and not change it and go with it. So at that point in time, circa 2005, even according to Attorney Ford's testimony, Chester Martin was aware of these issues, aware of potential causes of action, aware there might be an issue, and did nothing. No matter how we characterize the complaint, breach of fiduciary duty, undue influence, fraud, the respective statute of limitations would have expired around 2009. And I also know we're talking about fraud a little bit here. The only reference to fraud in the complaint is a one-word reference to it in the second cause of action, which is the intentional interference with expectancy of inheritance. First off, that cause of action was dismissed, so there is no fraud claim. Second, even a one-word reference to fraud is not sufficient under the civil rules to even allege a fraud claim. So even if that cause of action hadn't been dismissed, there's pleading, you have to plead fraud with specificity, and that wasn't done. Third, even if fraud was alleged, the elements of fraud have not been set forth in the briefs, and I don't believe they're set forth in the evidence. A fraudulent representation or concealment, reliance upon that representation, time, place, manner, those type of things. So I think we had an evidentiary break there too, beyond the legal break.
And I talked about your statute of limitations argument. You raised that originally in the first case by filing a motion for summary judgment. The trial court denied that motion for summary judgment. Mr. Martin appealed. You did not cross-appeal in that case, raising that issue. Why aren't you barred at this point?
I think it's a fair question, Your Honor. And first I want to apologize. It was me that had the wrong date in one of our briefs. I got 2016 and 2018.
But why would race judicata apply in that?
I think the answer is because it was renewed. First off, there's two issues there. The res judicata would solely apply relative to the denial of the motion for summary judgment. So once it went to trial, we would still have the right to say, listen, all this came out of trial and it shows the statute of limitations barred this. So the prior lack of appeal wouldn't address the trial that came afterwards. The second is the motion for summary judgment that was renewed at trial on the transcript in the second trial subsequent to appeal. So it was brought up again. But even, I guess perhaps the best way another way to respond to this is simply, even if res judicata apply, the first one or the renewed one, which I don't think it applies to the renewed one, but the same evidence came out at trial. It was all based on the testimony of a 24. So it's still the same evidence, the same timeline, probably without the tougher standard of summary judgment lying over it, frankly.
Counsel, regrettably, has your question been answered?
Well enough.
Regrettably, I need to let you know that your 15 minutes have been utilized. Thank you.
Your Honor.
Attorney Bernard, you will have 4 minutes and 10 seconds remaining.
Thank you, Your Honor. First of all, as to the jury instructions, we don't believe that the court needs jury instructions to make a determination of our assignments of error 1 through 3. I reviewed the transcript. I do not see the jury instructions in there. I believe there was a miscommunication between Mr. Kennedy and the court reporter as to what would be transmitted. I want to touch a little bit on the issue regarding...
Before you go there,
yes,
they are necessary, though, aren't they, for 4 through 8?
They may be, Your Honor.
Yes. Okay. Go ahead.
The fact about the deed and how that a deed cannot be set aside simply because of failure or lack of consideration. I think you touched on it, Your Honor, unless there's a showing of fraud or bad faith. Again, we have a power of attorney here who this court has said has a duty of good faith. There was plenty of testimony in the record from attorney Carl Ford that Mr. Martin, upon learning what he had signed, was absolutely distraught. And there was also, I believe, some testimony in there regarding he was fearful of Sandra because he was up in years. She was providing care. So that, I believe, gave the judge enough information or enough evidence to rule on our assignments of errors 1 through 3, mainly surrounding the validity of that deed. This is just not a failure of consideration only. We obviously, like opposing counsel and I have a different view of the case Wygan. I think I've already expressed what our opinion is of that, but I just wanted to point that out to the court. Also, as far as the statute of limitations is concerned, Your Honor, I believe you touched on our main argument here that this was brought up in the summary judgment in the first case. It was denied by the court. It went up on appeal, and there was no cross-appeal in that matter, as there is in this one. So we believe that they've waived that statute of limitations defense. Also, just touching briefly on the fraud cause of action. We didn't have a separate cause of action for fraud, it doesn't appear. There is just a little mention of fraud in there, but that fraud is mentioned, again, going back to the invalidation of a deed for lack of consideration, because one of those elements is fraud or bad faith by a fiduciary. So with that, I just wanted to clarify that in my rebuttal time. If there aren't any other questions, then I would complete my argument.
Seeing none, thank you.
Thank you, Your Honors.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to both sides, as well as posted on the Ohio Supreme Court website, which you can link to through the 9th District website. The court is